no annual dues, no annual fees, and no annual tax return. So those 10 trusts we just created will not yield 10 different tax returns. How many of you like that plan? Yeah. Is that a yeah, baby?
Yeah.
Yeah, baby. Now we're talking. Whoa! What can life look like without having all of that? Where can we go from here? What are our possibilities? We can buy houses right. We can buy houses cheap. We've got the opportunity to do properties subject to Does everybody know what subject to means? How many of you do not know what I mean when I say subject to? Is there anybody that... Raise your hand, be honest. Okay, good. All right. So subject to means we are buying the property subject to the recognition that there's financing against that property. We're recognizing that it exists. And we also recognize that if we don't make the payments, property can be lost in foreclosure. No different than it could have been done before we placed it in trust. So we're buying the property subject to the lien that's against the property. The lien is the mortgage. So we've got the opportunity to buy property subject to. We've got the opportunity to avoid FTB. Everybody know what FTB is? Franchise Tax Board. This thing over here. This is FTB. Okay? So, attorneys being servants of their clients, when the client comes to the table and says, I want ultimate liability protection. I want to make sure that they can't get me. So the attorney says, well, you need an LLC. How many properties do you have? 10. Okay, you need 10 LLCs. Right? Wouldn't that be the answer? That would be the answer, wouldn't it? Okay, you should get an LLC for each one of these businesses that you have. Each house being recognized as a separate business. So with each house being a separate business, then it's only times 10. Is that painful? Oh, this is annual. This is not like pay and forget about it. This is annual. Holy cow. I don't know how y'all live in this state. Look, they're just trying to run everybody out. I had dinner last night. Some of you met my student, Bruce Mack, that came over in the San Fernando Valley and got up and shared. How many of you were at the San Fernando Valley one? Yeah, and Bruce, remember Bruce got up and talked about how he had done 150 houses using my trust. He gave me some slides last night so I can show you actual checks and you can see the names on the checks and stuff like that. And we had dinner last night. He had a party and I had some people in and the guy was there. He's moving to Las Vegas. And I said, why are you moving to Las Vegas? He said, taxes. That was it. That was it. Taxes. Fascinating. Anyway.
Can I ask a quick question? Can the seller be a bank if the house is already foreclosed? Can this work?
No. You can buy it in trust. Let me clarify. You can buy it in trust. You can buy it in any entity you want to buy it in. They don't care what entity you buy it in. But no, they're not going to allow you to take over existing financing. You know why? It doesn't exist anymore. When the foreclosure occurred, that financing was wiped out. It was killed off. the bank, instead of the financing, got the collateral. So they now own the property. And what they're selling today is the property. Are they going to sell that with a loan? No. They want cash today. So you can buy it in trust, though. Yes, sir.
For a short sale,
Anything. Bank-owned property, it could. Short sale is prior to the foreclosure.
right?
After the foreclosure, it's real estate owned. It was real estate owned by the bank.
I have a question.
Yes, sir.
So if you own 10 properties, let's say in an LLC, can you retroactively go back and put them into trust? It's not really.
Well, it's not even
transaction.
retroactive. It's today. It's not even retroactive. It's today. Today, you make the decision. That wasn't a good plan. How many of you are on that page? That wasn't a good plan. Okay, new plan. You deed the property from whatever name it has now. You deed it from that name into the name of the trust. And that's merely the cost of recording a deed. So, for about $30, $30, we can move into a whole new arena. Paradigm what? Shift. We move into a new arena called privacy, asset protection, and probate avoidance. 3 things you can't get with an LLC. Oh, you know why I said you can't get that from an LLC? Because the thing the attorney doesn't tell you when he sells you an LLC, and probate avoidance. Probate avoidance. Okay?
Can you repeat, please?
So when privacy, asset protection, and probate avoidance, we're going to talk about that. So what the attorney doesn't tell you when he sells you the LLC, you said you wanted liability protection. What he gives you is an LLC. The LLC protects you, but let me ask you a question. Does it protect your assets? No. The assets are out in the open owned by the LLC. The LLC could be sued. Is that correct? And they could get a big fat judgment against the LLC and everything it owns. So if you've got 10 properties in one LLC, big fat judgment comes down, and believe me, all you have to do is read the newspaper on a daily basis. You will see these headlines of big decisions coming down. It's scary. It's absolutely scary. And you just don't want to be in that line of fire. So we think ahead and we say, okay, how can we protect ourselves from being in that line of fire? And this is what we do. Yes, sir.
I hear somebody that person had properties on the land trust, and then several properties on the land trust in an LLC. Is that good?
The LLC can be the beneficiary of the land trust. Absolutely. That's a good plan. So you can have one LLC as beneficiary of the 10 different land trusts.
Okay.
So that can give you protection. However, there can be some other ways to do that. So with the strategy that I was sharing with you, with the land trust being the owner of the property and the personal property trust being the beneficiary of the property, then if there's a lawsuit, this is you. And you hang out behind the trust, right? Because nobody sees who the beneficiary. First of all, nobody sees this second trust. Secondly, nobody sees who the beneficiary of this trust is. Is that a good thing? Oh man, that's like the keys to the kingdom.
With that,
So what she asked me to repeat it. So what I said is the piece of real estate goes in the land trust. Then the beneficiary of the land trust is the personal property trust. Now what just happened is this second trust, nobody sees. They would have to file a lawsuit against this land trust. They would have to have depositions, interrogatories, spend a whole bunch of money to discover who the beneficiary of this trust is, only to discover it's another trust. And the attorney said, that's so cool. That's so cool. Of course, he gets to go cha-ching. That's right. Billable hours, baby. This is a good thing. See, attorney only has one thing to sell. It's time, right? So the more time, right? It's a good thing. Now, that is a strategy. If everybody understands what just happened, it's a strategy to make it difficult for the other side, to make it expensive for the other side. Because there is a point in time when they typically say, Uncle. Uncle! I give up. What? Let's just settle. Let's just settle. I believe the statistic I read is that 88% of lawsuits in America end in settlement. They don't end in decisions from a court and a jury. They end in settlement. And the reason is, Uncle! It's too expensive. It's too expensive to take it all the way out to trial. So they go, okay, whatever. I forgot what I was mad about anyway. And then they're just mad at the attorney now. Because they just keep sending bills. Pardon?
They'll chase them around the tree rather than with a gun at the courthouse.
That's right. That's how it pretty much works out.
Can you notify the bank if I was to do that?
The only notification you're going to make to the bank is the change of address. So the change of address, we want now the mortgage information to come to you. We want the property taxes, insurance, and mortgage information to come to you, right? So we have to change the address at the bank because we don't want it to be mailed to the house any longer. We don't want it to be mailed to the house because we're going to put a tenant in there who's brain damaged. And basically, they're not going to give you your paperwork. They're going to lose it, and they're going to forget about it. And you don't want to trust the occupant of the property is going to give you your paperwork. So we're going to change the mailing address with the bank. That's all. Berta, that's all we're going to tell the bank. That's it. You see, the banks have signed something called a pooling and servicing agreement. And, the servicing agreement. So the servicing agreement says that they have to follow the details of that mortgage. They have to do whatever that mortgage says. Okay? So if you don't shake it in their face, they can continue to accept payments and not say anything about it. Now understand, we call them the lender. They're not really the lender. They're called a servicer of the loan. And they get paid for that. So they want to keep that train going. And if you don't make it difficult for them to do that, they will keep collecting those payments and registering those payments. And they will leave you alone. If you go shake it in their face, Berta, that can create a problem. Now they have to follow the guidelines of the servicing agreement, and that could result in them filing a lawsuit and trying to do a due on sale clause, trying to call the loan due. So I have certain procedures that I train you on, beginning on what page? 148, that tells you exactly how I want you to do this. And hey, listen, what you're taking advantage of is my 30 years of experience. So if I've never had a loan called in all these years, does it make sense to follow that advice? I'm not guaranteeing that it can't happen to you. I'm just saying there's certain ways you could do things that the bank will cooperate with, and there's certain things they won't cooperate with. And if you'll do it in a certain way, step by step, you won't have those problems. Is that a good plan? Yes. I saw a hand. Yes.
Back to the legal situation. Is there an order of magnitude as the amount of time for a lawyer to pierce the veil here? I mean, are we talking tens of hours, hundreds of hours? thousands of hours, a year, 10 years? How do you measure what that effort is worth?
It's called money.
Well,
It really boils down to money.
Somebody's paying the lawyer, how much money do you have to keep your parcel, pay the lawyer to do this?
yeah,
If the client is well-heeled, the attorney will continue to work. If they are broke, they will stop working. They won't tell you that, but they will. They'll just stop working. It's all about the hours. And if they're not going to get any money, I mean, this is pretty much how it works, right? That they're just not going to invest the hours if they're not going to get the dollars. So he who has the deep pockets, they will invest a lot of hours into. So in other words, they'll go deeper and deeper and deeper and deeper and create more depositions, interrogatories. They'll extend it out. They'll have multiple days. They'll have all kinds of other people they'll call into the case. They'll depose them. I mean, how deep are their pockets? We can go deeper and deeper and deeper and deeper. So they'll tell you up front, look, we can go this way, this way, this way, or this way. How angry are you? How much money do you expect to get out of this thing? And that's the fun part of this whole thing, is that nobody wants to spend that money. I mean, even as foreclosure defense, even banks who are stealing houses have a limit. For example, appeal. Once a decision has been